Alors, notre première séance de la
Panel this afternoon will deal with federalism at the Supreme Court of Canada, which is a nearly constant concern in constitutional work done by the court.
Wondering what it can offer you to follow up Justice Williams. It's suggested maybe metaphorical tap dancing. Metaphorical. Alors, j'ai l'honneur de vous.
I have the honor to introduce our moderator, Yves Sylvestre, who is the Dean of the Law Faculty at the University of Ottawa. And she has a doctorate from Harvard. She was a clerk at the court where she worked with Mr. Justice Gontier.
Present the members of your panel. Thank you.
Merci, Kwe. Bonjour. Good afternoon. C'est vraiment un immense.
Thank you. It's a great pleasure for me to moderate this panel discussion at a historic time for our court when it is essential that we celebrate the institutions that contribute to our democracy and the rule of law. The workshop will look at Canadian federalism and the division of constitutional powers. Federalism, of course, seeks to determine which order of government in Canada, the federal parliament or the provincial legislatures, has jurisdiction to legislate in a specific area within our federation. And of course, this is there is something even more fundamental at play, which is the division of powers, then the need for a proper balance between the powers of each level of government so that each has the autonomy and the scope for action needed. As pointed out by Chief Justice Wagner in the reference on carbon pricing, which was based on established case law, Canadian federalism tries to reconcile unity and diversity on both sides. And this, of course, creates particular challenges for the Supreme Court. And we're going to be looking at these various issues of things like Indigenous self-government and various areas of jurisdiction. I will first introduce Yves de Montigny, who is the Chief Justice of the Federal Court of Appeal. And he has 2 masters from the University of Montreal and Oxford. He began his career at the law faculty of the University of Ottawa, I would point out. He then held a number of key positions within the government of Quebec and Canada. He was a special advisor within the Quebec Intergovernmental Affairs Department, and he worked also within the Privy Council office, and he is a
Professor Emeritus at the University of Victoria and Honorary Professorial Fellow at the University of Melbourne. Professor Weber has written extensively in the areas of legal and constitutional theory, Indigenous rights, and federalism and comparative constitutional law. In the past, he has served as Dean of Law at the University of Victoria, as well as the University of Sydney. This bilingual workshop will proceed as follows in the first hour or so. Already looking at the clock. There will be an exchange between our 2 panelists who will be prompted by a series of questions divided in 4 parts. The first part will focus on the historical account of division of powers and what is fundamentally at stake when we decide issues of federalism. The second part will discuss doctrinal tools used by the Supreme Court in their interpretive behavior. And this will be followed by criticism to such doctrinal approaches, and we will end with possible alternative frameworks. This will leave about 10 minutes, hopefully, for question and answer from the audience. So let me set the stage for this conversation. Most people here in this audience will be familiar with the following account of the historical evolution of the Canadian division of powers. The Constitution Act of 1867 creates a federation, leaving subject matter of national and international importance to the federal parliament and local and provincial matters to the provinces. While both levels of government have equal authority and independence in their distinct spheres, the federal government has residuary power. From 1875 to 1949, during the Privy Council era, divisions of powers was interpreted using a watertight compartments approach that in many cases tended to favor provincial jurisdiction and impose significant limits on the federal government's capacity of intervention. Once the Supreme Court became the final court of appeal in 1949, there was a considerable expansion of the federal power, partly through POG, peace, order, and good government, trade and commerce, interprovincial works and undertakings, and perhaps most importantly, through the criminal law power. In the last 30 to 40 years, however, the court has settled on a more flexible and modern form of corporative federalism, allowing for increasing overlap and cooperation between different levels of government. Alors, Monsieur le juge en chef de Montigny, est-ce que ce compte-rendu omet quelque chose?
Chief Justice de Montigny, does this summary omit something important?
To be here today, it is quite intimidating, not only because of the topic, but also because of the distinguished audience. And I must say, and I think Jeremy will be in agreement with me, that it's even more of a task to do it now after the two panels we had this morning. So we debated for a few minutes who would be doing the tap dancing or the singing, but we'll probably skip that part. When it comes to division of powers, obviously, and questions of federalism in particular, it is important, it seems to me, to situate the doctrinal shifts that Marie-Ève has alluded to within the broader political, democratic, national context in which it takes place. Les décisions en matière de partage des compétences, comme vous...
Decisions dealing with the division of powers aren't strictly legal in nature, but are often of a political nature, in particular because of their impact on the validity of important legislation. They are also political because they often oppose provinces, or some of them, and the federal government, and they bring out various political visions on important issues and governments of different political allegiance. So all of those factors mean that these decisions are political as well as legal. What is even more important, though I feel, is that decisions in this area really reflect different visions of the very principle of federalism. Because federalism, as you no doubt know, isn't just a theoretical or a technical or neutral concept, but it really calls into play more fundamental considerations with respect to social and cultural values and relations between the two levels of government, even democratic legitimacy. So although federalism has been an inherent principle in our constitutional arrangements, it has been little used in case law. When we look at the Privy Council rulings, it isn't mentioned practically ever. But that is not surprising because the Privy Council members really didn't have expertise in that area because it was really more of a unitary type of government. Only more recently, since the 60s, and especially since patriation of the Constitution, that this has become more important in the Supreme Court's rulings. When we read the decisions, we can see that there are different perceptions, even fault lines, if I can put it that way, that have an impact on how we perceive federalism. I can give you a few examples of how the conception that we have of federalism plays a role important in decisions regarding the division of power. We had the 2005 reference on employment insurance, where the Supreme Court was called on to rule regarding paternity parental and maternity benefits and their validity. So often we come back to how a given judge will see federalism, and this perception can vary from one judge to another, and it really comes down to a political rather than legal perspective. When we look at the decisions to be made about division of powers, we see that there are different conceptions, and the basic issue is whether the legislation or the provision should come back to the local authorities or should be left to the national government. We had, back in 1991, we had a decision that showed that we had these different perceptions already, but more recently we've seen this when it comes to environmental protections and other such issues that involve both local and federal levels of responsibility. It's clear, from my point of view, that it is really the judge's perspective on federalism that comes into play. We have the double aspect approach, which is a little different from the traditional dualism approach. So, as some people would say, we have to take that into account, but also there is the failure of provinces, that perspective that comes into play as well. So we have the double aspect and competitive legislation. We distrust that perspective a little bit more because we feel that the local authorities should have some sovereignty, and therefore they should have the possibility of not taking action. When it comes to minorities issues, then we see that sometimes there are different approaches depending on the province. And we have to look at which government is best placed to deal with a given subject matter. I think that the reference on carbon pricing is a good example because federalism, as it is applied in Canada, has a very our perspective on federalism is a very important issue in our decisions.
Or the political character of division of power cases or conceptions of federalism?
Well, it's certainly the case that the division of powers has huge political significance. And I think one sees that especially by concentrating on one aspect of what Yves was saying, and that is the democratic significance of division of powers. We often talk about the division of powers as though it is an affair of governments. It's a relationship between governments. But when the court is deciding questions on the division of powers, they're also, in a very real sense, determining the political communities within which Canadian citizens participate in their own governance. Right? It determines who are the people with whom one has to persuade in order to be able to accomplish a particular end. It determines the structures through which one does that. It determines in large measure the particular society to which you will be focusing in the arguments that you're making with your fellow citizens. And that has real significance. It has significance with respect to the language in which the principal considerations occur. In Quebec, the predominant language of the discussions in the public realm that are then reflected in the political decisions is the decision that occurs predominantly in French. in British Columbia. It's not that the presence of Quebec within Canada doesn't have an impact on British Columbia, but the debate that occurs in French within Canada affects the British Columbia debates indirectly through the role of people who make it their business to be, in some ways, bridges between the cultures. And so it does make a substantial difference in the language in which these matters are discussed, also in those kind of the subtler vocabularies that exist within those major language groups, right? The particular way in which issues are discussed in Newfoundland or discussed in Ontario differs substantially from community to community. And those kinds of, those languages in two senses, les langues et les langages,
languages and language,
shape the debate that will determine those questions depending on the structure that ends up being decided through division of powers. And of course, it also has an impact on the scope of the decisions that are made. I want to make clear that in emphasizing the different languages that operate, it's also not as though one should always be focusing on the local as somehow more natural. We have very good reasons to collaborate on matters. There are issues that we face that we have to collaborate upon. And we have built a history of collaboration and interaction. There are distinctive resources that exist that are shared broadly among Canadians, that is a result of the history of interaction that we've had. I wouldn't have grown up in the country that I had it not, I grew up in British Columbia, had it not been for the presence of these other extraordinarily important societies, especially Quebec, within that national community and that national conversation. So, but it is true that the citizens with whom one is going to be interacting on particular issues, the intellectual resources upon which one will be drawing is, to a very real extent, a function of the decisions that are made on what are sometimes those abstruse questions of the division of powers. In that way, in fact, it shares a great deal with what was being discussed in the panel before this one, but just before the break. Indigenous governance, too, is, in your words, Justice Williams, the new vocabulary, the kind of different vocabulary that is brought to bear upon those questions, and a major justification for why Indigenous governmental autonomy matters so much is precisely so that those different languages of social ordering have their place, are able to develop within their institutional structures. And so broadly the questions that underpin the division of powers between Ottawa and the provinces also have this new challenge implicit within them of how then one engages this new old challenge, how one engages in Canada with a decent relationship among our political communities, our legal orders. The political nature of these questions then is present, although I think it's fair to say that it is in some sense a kind of meta-politics rather than, it's not about, when one is deciding a division of powers case, one should not be focusing on the particular merits of the particular policy choice that is before one, but one definitely is in the process of the definition and the capacity to sustain the variety of political communities, those that englobe all Canadians, those that draw upon our other political communities, and how those can be reflected in the decisions we make as citizens. And so it's that kind of meta-politics that I think is important to realize, that statecraft, what might be referred to in French as l'art de gouverner. It's often referred to that way, although I think it's extraordinarily important that we realize it's about l'art de se gouverner. At the foundation, it's a democratic process. And it has to be responsive, those democratic processes have to be responsive to our different selves and our different collective selves and how one manages the relationship among those.
You've used the term statecraft. I'm wondering if you can give us an example of what you mean.
Well, what is, I think, certainly there would be many examples in the history of the engagement with these questions within Canada. I guess my reading would be a little bit different from the one that we heard from Yves. This is now the 150th anniversary of the Supreme Court, but for almost half that period, almost exactly half that period, the Supreme Court of Canada was, of course, not the final court of appeal. It was the Privy Council. And during that time, after a kind of hesitant start, a kind of a trying out of different things, I think the Privy Council did come to realize that it had to protect the autonomy of the provinces in the extraordinarily important matters that were contemplated in Section 92. And it had to ensure that that autonomy was protected even as you had a pretty substantial transformation in the nature of governmental engagement with their societies through the growth of different forms of regulation. And that really set the kind of foundation for the structure of federal-provincial relations that we have inherited in many ways. It was fiercely opposed by many Anglophone constitutional lawyers, especially during the 1930s, when it was seen to be, argued to be, a departure from the structure that had been established in the original British North America Act. But my sense is they were, whether it was wisdom or it was the force of circumstance, they realized that this country had to have and had to maintain a substantial legal and linguistic autonomy at its very heart. And what strikes me is that even though those arguments were fierce in the lead up to the abolition of appeals to the Privy Council, in very substantial measure, the Supreme Court has carried on that essential relationship. It is true that there has been some life breathed into aspect of the Constitution that were the kind of principal focuses of the critics: peace, order, and good government, trade and commerce. But what is also amazing, most amazing, frankly, to me, is how much those powers end up being carefully delimited, restrained, to make sure that they don't gobble up the areas of economic regulation that were implicit in property and civil rights. And that essential autonomy, and so the kind of number of areas, though important, that have been upheld under those areas are remarkably few. And certainly not the kind of transformation to a regime of full-on federal dominance that some of the critics were hoping for.
Let me move on to the second part of our discussion. So clearly, division of powers decisions have significant political implications, but law is obviously not only about politics. So how has the Supreme Court of Canada, as an apex court, resolved disagreements about the proper allocation of power between levels of government, knowing these disagreements engage ideological visions of federalism without overstepping its role? Maybe starting avec vous, Monsieur le Juge-en-Chef?
Je peux commencer si vous souhaitez.
Oui.
I can begin if you like. Once again, I just want to react very quickly to what was said before by Professor Wetter. I agree with 95% of what he said, but I just and I don't want to say here that the Supreme Court has a political objective, clearly not, at least not intentionally, but when we talk about division of powers, when we make our rules, we talk about diversity, but we don't rule on whether legislation is desirable or not. But between the lines in any of our decisions, we have the reflection of the perspective on federalism of each different justice. So that's the only thing I just wanted to add to the discussion on the first point. So once again, as Justice Deschamps said a little earlier, that we have the division of powers and we base our federal system on that, but the objective is to maintain a balance between federal and provincial powers. And just to come back to what my colleague said earlier, we have English-speaking justices here from English-speaking provinces, and there were different views of the Privy Council office system that existed earlier. It was a quasi-federation. It was extremely centralized at that time. There were many exclusive and powerful federal powers. And now, when we look at much more decentralized federations, we see that the process went in the opposite direction. We had the opposite type of development. So I just want to mention that. The Supreme Court plays a bit of a referee role and tries to maintain a balance between these two fundamental values, that is, our unity and the diversity among the provinces. We want to bring together, to unify our values, and that is essential and must remain essential in our work. It's a continual process. We've been at it for 150 years, and we will continue to do this. There's a lot of virtue to the current approach, but it has to continue to evolve, and our society evolves. The Privy Council office's approach was more formalistic, and that is less useful in this time when governments have to regulate in so many different areas of citizens' lives. Therefore, the formalistic approach under the PCO is not well adapted to a cooperative type of federalism as we have now. We are really saying very much the same thing. You would think that we had written our notes together, but we didn't. The Supreme Court has acknowledged a number of times that cooperation has to be there for federalism to work well, but this can never override the division of powers constitutionally, and this is important in this new paradigm of cooperative federalism. The division of powers has to be based on competition, the double aspect, as mentioned already. It is not only necessary but desirable that both levels of government play a role in a given area. That creates concerns, though, because the double aspect approach means that the federal government gets involved in areas that are considered provincial jurisdiction. The expansion of federal legislative powers for example, beyond criminal and trade and commerce areas, it can be difficult. For example, we already talked about the reference on the carbon pricing, and in that case, we saw a tendency to move into areas that had been considered exclusive provincial jurisdiction. And in some cases, there are federal intrusions in the subject matter areas that really are exclusively provincial. As Jean Betts wrote, before he became a Supreme Court justice, this lenient approach can create confusion between political science and law, and can even interfere with a proper interpretation of sections 91 and 92 of the Constitution. This is problematic not only for Quebec, but for all provinces in their jurisdiction. So the watertight compartment approach taken under the Privy Office era is no longer valid. Another aspect that we need to pay attention to is effectiveness. When it comes to trade and commerce, that's one thing, but it has expanded in its application by some to other areas, and that gives the federal government a paramountcy that may not always be justified. Obviously, if we look at every area and look to see where action needs to be taken, then it could be said that the federal government might have a paramount role if no action is being effectively taken. So in some cases in the past, if the federal and provincial governments were involved in a given area, then that indicated that the province should withdraw and this should be under federal jurisdiction. But in many Supreme Court decisions, we concluded that there isn't necessarily a conflict between the two levels of government working in a given jurisdiction. If there is an incompatibility, then there is going to be an accusation of intrusion into provincial jurisdiction. So I don't think that we want to go back in time, but I think there's a tendency to put a lot of emphasis on effectiveness.
Well, I know that there has always been a position very common among jurists in Quebec, constitutionalists in Quebec, especially Francophone constitutionalists in Quebec, of the risk of a departure from formalism, a kind of sense that having a bright line is important to be able to preserve Quebec's jurisdiction against erosion. But I have to say that when I look at the decisions, my sense is that in fact formalism did not serve Quebec very well. It ended up cutting off the operation overwhelmingly of provincial legislation because of its encroachment on what were taken to be on the federal side of the line. And my sense is that from the change to a less formalistic system, one that is more forthcoming about the fact that it is a balance between jurisdictions that is being managed, has actually served provincial interest. For one thing, the change in the rules with respect to conflict and paramountcy has in fact allowed provincial legislation to operate in areas where, as you say, it would once have been excluded and rendered inoperative. Yeah, absolutely. And so my sense is really that Well, in fact, my sense is that the formalistic view fundamentally is about a notion of exclusivity of powers that I think is not my understanding of the exclusive. I do think the powers that are conferred in Section 91 and 92 are in a very real sense exclusive, but it's not as though there are beings walking around Canada who either have a provincial or a federal label on it. It really is the legislative orientation that's exclusive, right? The impulsion of the legislation, not the objects that it's affecting. And it's very possible, in fact, it's the norm, to have both federal and provincial legislation affecting those beings in the world simultaneously. And it makes good sense for that to happen, right? Take an area of undoubted provincial responsibility, education. In the relations that occur between teachers and students in the classroom, the criminal law continues to operate and continues to set outer boundaries. And that makes sense, even in that area. And that, I think, is an example that shows that it's the legislative orientation that is allocated to one side or the other, but not not the kind of object to which it attaches. And I have to say that the kind of principal decision of Justice Spence when he was on the court dealing with these matters, the Bell Canada and CSST case, is the outcome's regrettable, right? One has a situation in that case where, because you're dealing with a communications undertaking, the decision was that matters dealing with labor relations could not touch this entity because it would be touching an essential part. Well, first, the outcome is illogical because although in successive decisions, minimum wage legislation, legislation for health and safety in the environment was excluded from operation, collective bargaining, provincial collective bargaining legislation is excluded. If you're dealing with the individual contract of employment between a Bell Canada executive and Bell Canada, it's governed by the droit civil, by the provincial law, right? And that makes, and it would be wonderful if one could have the provincial law also applying when you're dealing with contemporary social policy, right? One good reason for that too is that along with those areas of responsibility comes an area of specialization, of knowledge, of focus. I have to say, I don't like talking about areas of overlap purely as though it was a matter of cooperative federalism. It isn't always cooperative. Sometimes it is cooperative, often it's competitive, and competitive for good reasons, right? So if you look at the communications power in Canada, it has tended to be conceived, looking at federal legislation, to be primarily concerned with the allocation of a scarce asset, electromagnetic spectra. Consumer protection, if it's anything, is an afterthought, a very small afterthought, right? Wouldn't it be good to have Quebec's extraordinarily sophisticated consumer protection law as applicable to the communications undertaking, right? They have the bulk of the presence in the area. They have the bulk of the expertise. And that kind of lack of expertise and its consequences for the outcome is something one sees again in another federal area with the long, protracted litigation around the Caring Society cases with respect to the substandard provision of social programs to First Nations on reserve. Now, there are many reasons, some not at all creditable for that, but one of the things that also feeds into that is, this is a tiny portion of the role that the federal government serves. Social policy is not their core business, and they don't have the expertise to deal with that. Now, of course, in that instance, the people with the expertise are the First Nations themselves. And having those experts have powers recognized to be able to deal with those issues in a manner that is responsive to the distinctive vocabularies, legal vocabularies, the distinctive bodies of knowledge, sense of social ordering in those communities would be the way. And I am not worried by having an emergence of an approach where you have a measure of multiplicity of presence in a particular area that one has with the body. And and my sense is that it's ended up producing a net increase in the effective authority of the provinces as opposed to a net decrease.
Donc, le professeur Weber a mis l'accent sur certains risques.
So we could talk about certain risks now. We've talked about some. Are there any others that you would like to bring up, Chief Justice, when we talk about a cooperative or competitive division of powers? Well, once again, I don't question the worth of cooperative federalism. I think in this day and age, we have to have cooperation between the two levels of government. The nature of the problems that they are dealing with, whether we're talking about the environment or many other problems, then that's going to require cooperation with the federal government and, of course, around the world among governments to deal with these issues. We can't deal with them or resolve them in isolation. But I think there is a risk in cooperative federalism. If a subject matter is important, it needs us to be effective. And we've never really pinned down what effectiveness needs or the failure of a province to act. Does that mean that the province has failed to take its jurisdiction, or what if a province decides not to legislate in a certain subject area? Does that mean that the federal government can walk in and use its own legislation? In the case of the reference on carbon pricing, the difficulty was that some provinces decided to take a different approach from the federal government, and the federal government said, well, you can take different measures, but you basically have to do what we say. But why not allow for greater diversity? That is the objective of federalism, after all, that we should have common objectives, but to encourage different approaches and some experimentation. So in case law, in certain cases, there has been emphasis on this in lack of effectiveness in action. But it seems to me that we could have a better balance so that we could allow for different approaches by the provinces and to give greater latitude in many cases to the provinces that sometimes have very worthwhile approaches and initiatives. Thank you. So We have talked a lot about cooperative federalism, but we will move now to different approaches. Are there other models that we could use when it comes to respect for jurisdiction? It seems to me, when I was preparing for today's symposium and reflected on this, that one concept that could be of use, and I don't mean that it is going to solve all of our problems, but it could create a better balance for us, would be that of residuarity. And it's very much more prevalent in Europe, and perhaps it would be better to look in this respect at what is done in Europe rather than what is done in the United States. When we look at how the Constitution initially distributed our powers, then we had subsidiarity rather. This was a secondary principle, and it is not something that is not compatible with our institutions, basically. And I don't know if everybody knows what we mean by subsidiarity. It means the question of which level of government is better placed to deal with a certain subject matter, the one that is closest to the citizen or better placed to deal with it. So this creates greater awareness and sensitivity to the needs of local populations. And also, it promotes greater diversity of approaches. Right now, the Supreme Court has signaled this in various recent decisions, that this is something that does probably have a role in our reflections in the future, so that we can be more attuned to local interests, and thereby having that level of government be responsible. It could be downloaded even from the provincial government to more local levels of government. The Supreme Court agrees that this approach is valuable, but we have to see how we're going to use this principle. We had a good example in the reference where all the justices talked about subsidiarity, but everybody's perspective was a little bit different. I don't think it's a panacea. It won't resolve all of the tensions that we have with the division of powers, but I do think that it's a concept that can make us assess more closely what the role of the provinces can be. In Europe, for example, we see a more formal elaboration of justification required when the central government wants to take responsibility for a given power. So we'll see where this leads us.
Well, before that, I guess I'd like to just say that there's another thing that Yves and I agree on, and that's very much this emphasis on experimentation, right? If you look at Canadian history, there's no doubt that experimentation, a lot of the programs that we now take as kind of quintessentially Canadian, in fact, emerged out of that experimentation and continue to, right? We can kind of think of the waves that have occurred over the course of of my career, you see this kind of radiating out of models from one jurisdiction to another in ways that I think are quite interesting and that suggest that efficiency is not always served by a single answer, as sometimes the language of efficiency tends to suggest. I also think that we get better outcomes if we do consciously turn our mind from the fact that federalism is not just about an affair of governments. It also is about the sustaining of our various political communities and that kind of democratic grounding in those communities of endeavor. I think it's communities of discussion, of discourse, of normative tradition. It's hugely important that we continue to pull ourselves back to that. Now, I guess my sense of the case that you've spoken about, the greenhouse gases case, is there was an attempt to kind of find a balance between the differentiation and a kind of contribution on the world stage to that huge challenge that none of us have kind of come to grips with. And so I guess I have some sympathy for the attempt to allow a contribution, potential contribution to handling that huge problem. On subsidiarity, I agree with just about everything you say about why subsidiary is valuable and how it ought to be understood. I guess what worries me, though, a little bit about that, at least as if that's our exclusive recourse, is that it runs the risk of substituting another vague concept for the vague concepts that we already work with, right? Because subsidiary is given kind of substantially different meaning in the times when it's evoked, and sometimes with a heavy emphasis upon economic efficiency, especially in the European Union, as being a driving feature for what goes centrally. So I confess that I'm a little bit, although anything that gets us to think about the issues afresh is useful, hugely useful. I think we do not want to neglect the tools that we do have already, because there's unfinished business to do. We talked about the fact that the engagement with peace, order, and good government and trade and commerce has been kind of framed by the tests that we referred to that really result from contributions of Justice Betts when he was on the bench. But the criminal law power has not had those constraints read into it. It is highly dependent for its substantive dimension, which is hugely important, on a catch-all list of categories which are hugely capacious, health being huge, for example, among them. And it seems to me that we need better tools as the criminal law comes to be used as a hook upon which to hang quite complex regulatory structures. We can use better tools for achieving the balance there. And I think speaking about one of those tools that I think actually comes together very closely with subsidiarity is the one that really emerged in the context of what's sometimes been called the ancillary power within Canadian jurisprudence, and that is the kind of sense that there has to be, if you're dealing with an issue that deals with that, what looks like an intrusion upon an area of provincial responsibility, it's wise to assess the balance between the intrusion and the centrality to the federal power that is purported to be exercised. Because if the intrusion is out of balance with the importance to that federal power, this should be perhaps treated as something that goes too far. Now, we use that in the ancillary power base. It's one of the components of Betts's test for the national dimensions, but it's not used more generally. And I wonder whether, perhaps because the balancing tests look like they are too fluid, but that kind of directing attention to the extent of the intrusion specifically and gauging it against the centrality to the federal power that purports to be used, I think ought to be important to the division of powers reasoning more generally. And in fact, I think one does see echoes of it, especially in the determination of pith and substance, the kind of essential nature of some of the powers. And I think that's one that I think could be coupled with the language of subsidiary, but also has the benefit of carrying with it the distinctive Canadian history in the context of the Canadian division of powers. I think the provincial inability test also has a kind of echo of subsidiary in it, because it implicitly presumes that the power should be provincial unless they're unable really to exercise it. And that kind of focus on externalities is a kind of question that may be a trigger for federal authority, I think does make sense. And I think a generalization of those two that do crop up in different areas, but I think would be one way of helping us to think through these issues in a way that may capture at least one of the two areas that I think still needs work. One is the criminal law, as I've said. The other, of course, is the spending power, which really for kind of reasons of strategy really doesn't come in very useful fashion before the courts, and is one that one continually hopes will eventually produce a negotiated settlement, as indeed it would have had Meech Lake gone through.
Mm.
Yeah.
Thank
Can I
you.
pick up on
Yeah, I
just
was going to
one
ask
little
it if
thing?
you wanted to react before.
I tried to talk so you wouldn't have time.
Because I'm in agreement with
Of course.
But you said something which I think is extremely important, and that goes beyond what we've discussed so far. But you mentioned that federalism is not just for the courts, but also for the people. And I think that's absolutely true. And it's the same thing as for human rights. You need to develop a notion of federalism in the country for the people. And one thing that I personally regret is that there used to be in the past a lot more exchanges between the federal and the provincial public service, whereby the provincial civil servants would learn what it is to be in Ottawa trying to manage things for the country in general, and in the reverse, for federal officials to go to provincial capitals and see what it looks like when it comes from the big brother in Ottawa. And I think this kind of exchange is extremely important, and it's too bad that we don't see it as much as we used to in the past, and that would percolate, hopefully, in the population at large, because you cannot have a federal country if people don't see a benefit of working as a federation, and I think it's essential.
Yeah, good.
Great. So now I'm turning to the questions from the audience, and fortunately I've got quite a few. And I'd like to start with this one. Given the fact that the shifts in the balance of federalism between the unity and the diversity of the components is also a reflection of the broader democratic context, what do you make of the current threats to Canadian sovereignty? And do you believe that this will put pressure towards more unity than diversity?
Well, thank you.
That was not prepared.
Maybe you can answer by singing.
That might be a better contribution, even with my singing voice. But so one of the things about living in such a complex country is the things that are most valuable kind of are subtle, and they kind of percolate through, and one perhaps doesn't entirely realize their importance until they end up looking like they might disappear, and you suddenly think, oh my goodness, that's more of a worry than, or I didn't realize I valued that as much as I do. And And that seems to be one of these moments, doesn't it? It seems one where, for all our challenges in making a bilingual society work, and more than that, seeing the value in what it has given to us over the course of our professional lives, when there is a prospect of having that effort, that discussion have very little place within broader North American society, one realizes just how precious and valuable that has been, and how much we've learned from that, from living it. I referred earlier to the Privy Council, perhaps by force of circumstance more than anything else, coming upon the result. And I think so often we learn things that way. We don't learn them so much intellectually as we realize, oh my goodness, that was something that valued, and it could disappear, and that would not be so good.
Any comments? Or you'd like another question?
I'll take this one for now.
Yeah, good.
Je pense que c'est évident.
I think it's obvious, a priori, and in the short term at least, that any external threat, and I don't want to be over dramatic here, has a direct impact by unifying people, and this is the case around the world in any country. We can see in the polling in Canada, in Quebec, but elsewhere as well, that people are kind of coming together over this. And one of the indications of the collective effort that we're called on to make is to see whether we can actually achieve a free market within our borders. Everybody thinks that this is the way we should go, and we do need to do a lot of work in that area. And this certainly has a direct connection with the division of powers. We won't get into all the details of that, but will this determination to work together to increase interprovincial trade, will this desire remain? I think that in Quebec, and probably in other provinces as well, that people will say, well, we have to preserve our identity and so on. So I think it's a little bit too early yet to see what the impact will be in the medium to long term on federalism in Canada. Thank you. One last question, perhaps.
Hear about the importance and diversity of political communities for federalism, and how they must be considered in that work. So what about the role of Indigenous self-government? Is there space within Canadian federalism jurisprudence to ultimately recognize another level of government?
So I think the underlying impulsion to do something about that, I think, is related to what we've been talking about when talking about federalism. Making sure that First Nations as political entities are able to draw upon their distinctive languages of social ordering and their distinctive norms, their vocabularies, in the organization of their societies and their contribution to the broader Canadian and provincial societies. So I think that there is a huge kind of foundation of principle that underlies both those kind of structural dimensions. I think the challenge is how to achieve that. And I think in terms of the actual adjudication of it, of those questions, one is stuck upon has been stuck up. There's now quite broad, I think, acceptance that self-government is something that ought to be exercised by First Nations. The problem with the adjudication of that, I think, is stuck upon what Lemaire put his finger on in Delgamuukw, which is, he takes one look at this and he says, the Royal Commission on Aboriginal Peoples took 277 pages to discuss this. How can we deal through an adjudicative process for all the complexity that would be involved in the recognition of different First Nations and the Inuit and the Métis within this kind of broad structure? How do we, through an adjudicative process, actually handle all of those, the panoply of questions that would result? And hence you have the emphasis in many decisions towards the negotiation of those questions. Or within the abortive Charlottetown Accord, a kind of managed negotiation, a kind of by analogy to the duty to bargain in good faith. So that there's that problem. I guess the one kind of question I've had about whether it might be a solution to it is by bringing in as one of the resources, the notion of framing norms. We tend to think of rights as though in the adjudicative rights, the result, we should be able to, as a court, we should be able to actually define specifically what the content is that's required by this right. But are there norms that don't presuppose a highly defined content, but instead a broader objective that could be attained by a whole variety of ways? Those of you with an understanding of the European Union will realize that that distinction exists there, right? Between regulations, which are directly operative and which states are bound by in their particulars, and directives, which operate at a broad level of generality. The states still have to attempt to achieve them, but they have a wide variety of ways to achieve them. And it seems to me that there's one power in the Charter that operates in that kind of way. That's freedom of association. Remember when freedom of the question of labor rights under freedom of association was first being discussed, there was the question of whether, does this mean that a labor code is kind of entirely captured within that phrase freedom of association, so that we've essentially constitutionalized the labor codes? And I think the answer we eventually came to was no, but there has to be some mechanism for the effective participation in the terms and conditions of employment for employees. So you have a variety of ways, provinces and the federal government, to achieve that, but it has to have that outcome. And I wonder whether that kind of, there's not a kind of dictation of the detail, but a decision as to whether a particular approach complies, achieves, serves that particular end. And I wonder whether that approach might achieve something like the outcome that was presupposed in Charlottetown, a kind of where the outcome is not prescribed, that is left to the negotiation of the parties, but with this impulsion to speak to this more general end. But it's, but those institutions have to be rebuilt from the ground up. Those relations have to be built in a more decent foundation. And the real action, as it often is of course going to be in the initiatives that are taken by communities in their own governance and in their own efforts to articulate what kind of relationship with other governments makes sense.
Merci. Certainement un agenda politique.
Thank you. That's certainly a political agenda that will engage the public, the federal government, all the governments, and the Supreme Court for the next 150 years. Thank you.
know I speak for everyone here when I say you succeeded in getting us to think about issues of federalism afresh. You've also succeeded in reminding us just how important it is to the structure and culture of our democracy in Canada, and for also reminding us about the common themes of all of the big issues we've been talking about today here, and themes that, although always feels a bit made in Canada, these are themes that resonate around the world. So thank you so much for just another fabulous session. Thank you.